Mr. Delaney, let me ask you a series of questions here. My first question is, did you disclose this case in the questionnaire that was submitted to you for this nomination?
If you're referencing to the 10 top cases that I was asked to disclose, Senator, I did not. In part, disclosing cases that are controlled by confidential settlement agreements is something I think all applicants to this process take into consideration. The other reason it's not in there is after this pleading was addressed, there was very little additional courtroom work in the case before the case settled. So there just wasn't a lot of legal proceedings in this case other than the first motion we've discussed.
Did you think that this would not become an issue in your confirmation hearing?
No, I was aware that questions had been raised regarding it, Senator.
So as I understand it, you filed a motion to remove anonymity from the victim of the sexual assault, but the court never actually ruled on it. Is that correct?
The school did not file a motion to remove anonymity. The school filed a motion assenting to anonymity at pre-trial stages, provided the lawyers were restricted from trying the case in the media. That was the motion that was filed, and it was never ruled on by the judge because it was withdrawn before the judge had an opportunity to consider it.
So it was a conditional motion, conditioned on the court instructing the lawyers not to try the case in the media?
It was a conditional assent to the request to proceed anonymously, provided the judge imposed conditions requiring the lawyers to try the case in a court of law and not in the media.
And so if the court had not ruled on that, that portion of your motion with regard to trying the case in the media, would you have proceeded to seek to identify the victim in the court proceeding?
No, Senator. The school did not seek.
Well, I don't understand your statement then. You said it sounded to me like you're saying you conditioned your assent to anonymity on the court ordering the lawyers not to try the case in the media. And I'm asking if the court had not ruled on that portion of the motion with regard to trying the case in the media, would you have withdrawn your assent to proceeding anonymously?
So that matter was never presented, Senator. My expectation is that if the school did not get the conditional relief that it wanted, given the age of the minor, my expectation is that the case would have proceeded with her using anonymous names. That's my expectation as to what would have happened.
You mentioned a case in the District of Columbia, I believe it was Doe versus Cabrera, that was the precedent that you sought to apply in this case. But in fact, in that case, the plaintiff was not a minor at the time of the incident, and at the time of trial was a 27-year-old. So how is that analogous to the case we're referring to?
It's not analogous relative to the age of the participants. That's a clear distinction you're identifying, Senator.
But on what basis would you argue that an adult, that would be analogous to this minor?
That's not an argument I would have made, and we didn't make that argument. The reason we presented that case to Judge Barbadoro was because Judge Walton had granted anonymity in the case and coupled it with an order requiring the lawyers to try the case in a court of law and not in the media. So the relief entered by Judge Walton was to allow that sexual assault victim to proceed anonymously and to tamper down what the lawyers were doing in the media. That is the request we made of the federal court in New Hampshire. I agree the factual standpoint of that case in terms of the age of the parties was quite different.
Well, the victim in the St. Paul school case the trial against her assailant resulted in a conviction, correct? In a criminal court.
It did. Owen Labrie sexually assaulted her. He was brought to justice by a jury, and he was convicted of that sexual assault.
And did your client settle the civil case by paying the victim money?
This is where I'm bound by my obligations of a confidential settlement agreement, Senator. I'm prohibited, given my duties as an officer of the court, from answering your question.
Is that a court order?
There's a confidential settlement agreement that would prohibit me from addressing your question.
So if I looked at the court records, what would the judgment in the civil case reflect?
You would see a stipulation of dismissal filed by the parties, and you would see nothing about the specific terms on which the case settled.
Thank you.
Senator Cruz?
Mr. Delaney.